Thank you, fellow board members, for joining me today. Quorum has been established. I appreciate your continued commitment to the people, to this board, and to the people of New York State. Now, before we begin, I want to remind everyone about a few important ground rules. For those joining us remotely via Zoom, you have been entry and will remain muted throughout today's meeting. There will be no public testimony. Any distracting video will be. Members are joining this meeting from 3 physical locations: video conferencing, Albany, Buffalo, and New York City. This is an open public meeting in compliance with the Open Meetings Law, and it is being recorded. Recordings and other details of the board's work are available on the Department of Labor's website. I want to take a quick moment to remind the board that if any members have any written material that they would like to submit for review or consideration, those materials must be submitted at least 24 hours in advance. This will give members time to review the material before meeting, and so we can share the materials with the public as necessary. I'd like to give all of my fellow board members the opportunity to introduce themselves, beginning with the members who are here with me in Albany, followed by the board members attending at the Empire State Development offices in Buffalo, and concluding with members attending at DOL's Church Street location in New York City. Let's start with Al Catalano.
Good morning, all. My name is Al Catalano. I'm Secretary Treasurer of the New York State Building and Construction Trades Council.
I'm Commissioner Roberta Reardon.
Sean McCready, Director of Public Work and Secretary to the Board.
Chris Alun, retired.
Dan McGraw, the New York State Conference of Operating Engineers.
And in Buffalo?
Commissioner Knight.
Thank you. And in New York City?
Gary LaBarbera on behalf of the New York City Building Trades Council.
Jim Whalen on behalf of the Real Estate Board of New York.
Hugh Florio on behalf of Long Island Builders and New York State Builders Association.
Thank you very much. We are also joined by members of the department's counsel's office who will be here to consult or provide guidance if we need a legal perspective at any point during this meeting. Additionally, I realize that while many members of this body serve or have served on private boards, for some of you, this might be the first time serving on a public board. To make sure everyone is informed, I've asked Department of Labor General Counsel and Deputy Commissioner Jill Archambault to provide us with a brief presentation on the rights and responsibilities of a public board and its members. Deputy Counsel Laura Campion is also here to help any questions you may have. Jill?
Great, thank you. Hello, everyone. I'm Jill Archambault, General Counsel to the agency. Thanks for having me today. And now that the board is going to embark on its substantive work, we thought this was a good moment to step in and just give you a few reminders about different aspects of serving on a public board, what could come out of some of your service, etc. We received some questions from different board members over the last few weeks and over the summer. So my goal is to try to address some of those questions. And then at the end of just my remarks, open up for some Q&A if anyone else has questions as well. So at the outset, we understand that you are serving on this board in an unpaid capacity, and no one expects this to be your full-time job. So we want you to understand that at your disposal are the department's resources, including program experts and legal. So if you have questions and as the board is going through its work, please consult us so we can weigh in and give you some advice or guidance on whatever those issues are. We're going to do our best to assist, but as you all know, this is a really unique board and you're really just getting started. So we appreciate your patience at the outset as we do work through some of these new or unique issues. At your very first meeting, you heard from Jerome Tracy. He was the ethics officer for the agency, and he gave you some reminders about applicability of the public officers law to you all as board members and said, call him anytime if you had a question. Mr. Tracy has since retired, so I'm letting you know that I am currently the acting ethics officer, so I'm stepping into that position at least for now. If you do have questions about conflicts of interests, appearance of a conflict, questions about financial disclosure statements, etc., I'm happy to try to help if I can, or find you someone that can help. Similarly, as board members, your statute allows you well, unpaid, to be reimbursed for necessary expenses that you may undertake in the performance of your duties. So really, I'm talking about travel. So if you do have to incur travel expenses and you would like to have those expenses considered for reimbursement, let us know, because we can look at the state policies and procedures as well as the state comptroller's policies and procedures and figure out like the best way to handle that. So please don't be shy about that if you have a question. as you get into your substantive decision-making, the board is going to decide things about specific projects or big concepts like the commissioner is going to get into today about how different concepts apply to all projects. And it's possible that there could be lawsuits or appeals that come out of that activity. Your statute envisions an Article 78 proceeding to challenge any of your decisions. So I just wanted to briefly address what is an Article 78 proceeding. That is, we call it an Article 78 because it's governed by the Civil Practice Law and Rules, Article 78. And ultimately, it's a challenge where someone could say, a New York State official or an administrative body like this board made a decision that was unlawful. And the petitions are heard by the trial court level in New York State, and the law gives the body a lot of discretion. And generally speaking, what they're looking for is whether or not your decision was arbitrary or capricious. So more specific to what might be on your mind is, what do I do? What if there's a lawsuit? Like, what does that mean for me? It means that as board members acting in your official capacity, there's a high likelihood you're covered by Public Officers Law, Section 17. My office would help liaise with the State Attorney General's office to get legal representation for you. So generally speaking, the Attorney General's office would represent you and the board absent some conflict. And if there was a conflict, there would be an analysis about whether the state would cover your private legal expenses. Similarly, if there's a settlement or a judgment where money is due, no one is going to ask you to write a check or take your house. It would come out of the state funds under the same statute. But again, I mean, this is talking about acting in your official duties and it's all fact dependent, but we wanted you to know that at least in the first instance, the state steps in. And then additionally, if there are challenges and other things that come up, questions have been asked to my office about confidentiality. How does confidentiality apply to this board? It is a public board. You have open meetings like the commissioner just reminded us all, but your statute is unique and it allows you to have confidential hearings about specific projects. So the legislature envisioned there being some private discussion that might protect specific developers, their financial issues or some of their, whatever's going on behind the scenes of these projects. So that issue could come up in a few contexts. One of them is when you're holding a confidential hearing. So the existence of a hearing itself is not confidential. It's more what's happening at the hearing and the documents that are being produced, the reports maybe that the Bureau of Public Work writes or that the department produces, reports maybe that you're producing for the purpose of the hearing. So there's different ways to handle that. And generally, when witnesses come into the room to testify at those hearings, when you call them in, one way to mitigate concerns about someone sitting through an entire confidential hearing and just listening to all the discussion and testimony is you have options about how you want to handle that procedurally as a board. So for example, you could say, we only want one witness at a time in the room, so they're not hearing the entirety of the hearing, things like that. And as those issues come up, my office is available to help come up with some mitigating strategies to make sure that the board members and the board are comfortable with the process and make sure it's legally defensible. One other context where confidentiality could come up is a FOIL request. So the Department of Labor, by default, our records are subject to disclosure under the FOIL statute, and so is the work product of this board. However, you do have this special confidentiality provision in your statute. So if there is a FOIL request for some of the documents related to projects or these confidential hearings or produced by the board, in the first instance, the FOIL experts in my office will take a look at that and do an analysis about what exceptions could apply or not apply. And we will do our best to keep all of the materials that should be confidential in that context. Similarly, if there is a lawsuit or litigation, we in the Attorney General's office will make arguments to keep those materials confidential throughout the discovery process. There's different tools like asking the judge if it's provide materials for the judge's eyes only or for the opposing counsel's eyes only. And then lastly, on an individual basis, it's all your responsibility as board members to help maintain that confidentiality. And so public officers law, which I mentioned a minute ago, the ethics law, does consider confidentiality and what you use information, if you're using it for your personal gain or if you're disseminating it, you could be violating the ethics law. So just keep that in mind as individuals. But we're confident that this is a responsible board that is all interested in doing the right thing. So if any of these things come up, the point is we're here to help. We're here to help you find solutions, and we want to be partners with you as you begin this very unique endeavor. And as far as this board goes, it's unique in DOL, it's unique in our labor law. And then my colleague Laura Kempion is here too. So between the two of us or our team of about 40 more people in our office, we hope we can find answers for you. So thank you very much for having me.
That's great. Thank you so much. It's very important information. Do any members of the board have any additional questions for Jill and Laura on their rights and responsibilities? Anybody? No. Okay. Well done. So now I'm going to ask the board secretary, Sean McCready, to provide us with an update on actions taken by him and the department's Bureau of Public Work.
Thank you. So just let everybody know the PW 39A form that's referenced in the board's procedures, the certification form, is online and up and running and available for use. The form can currently be found at the Bureau of Public Works webpage, along with the rest of our forms, and will soon be up on the board's page. Additionally, a 224A information page is going to be added to the Bureau of Public Works overall website. I'll put the form there as well with some additional information for it. Since the last board meeting, there has been one project submitted for board determination. I've prepared an additional report for you that'll be provided a little later this morning. It was not included in the report I sent to the board members on Friday, as the certification form just came to my attention yesterday. So it was a separate report that was prepared. In doing this, a small gap in the procedures was sort of discovered. The projects in the first report that I sent on Friday did not come in as a request for board action. They came to my attention as the public work director. And in the procedures, it simply calls for the secretary of the board to notify the board members within 5 days of a certification request. In the interest of transparency and just providing the board members with as much information as possible, going forward as board secretary, I'm just going to prepare a weekly report and email the board members at the end of each week with a Excel sheet, essentially listing all projects that the Bureau of Public Work, in its capacity as assisting the board, is looking into, whether there was certification or request for determination or not, just for quick reference, and so that the board members have all the projects that are out there that we're aware of at their fingertips. And that, I believe, sums it up.
Okay, excellent. Any questions, comments? Perfect. So at the last meeting, this body decided to do a separate resolution on how the board will handle media inquiries. I move that we resolve to have all media inquiries regarding the business and operations of the board directed to the chairperson of the board. Do I have a second?
Second.
Thank you. Thank you. Do any members have any questions or comments on this proposed resolution? Anybody in? Nope. All righty. All in favor of the proposed resolution, please say aye.
Aye.
Opposed, please say nay. Abstentions? Excellent. It's unanimous. The motion carries. The board has resolved to have all media inquiries directed to the board's chairperson. Thank you very much. As a reminder, we need 7 affirmative votes in order to approve any resolution. That's our quorum. We have 8 people in the meeting right now. Moving on to our next agenda item. This board is permitted under Labor Law Section 224C to make recommendations related to the requirements of Labor Law Section 224A. Specifically, the board is permitted to make recommendations on the 5 following items. I think you have them in front of you. 1, the minimum threshold percentage of public funds that will qualify certain construction work as a covered project under Labor Law Section 224A, provided that the threshold cannot be lower than 30%. 2, the minimum dollar threshold of projects that will qualify under construction work as a covered project under Labor Law Section 224A, provided that the threshold cannot be lower than $5 million. 3, construction work that is excluded as a covered project pursuant to Labor Law Section 224A 4C, which excludes certain affordable housing projects and provides the board with the ability to exclude additional affordable housing projects. 4, the definition of construction for purposes of Labor Law Section 224A, and 5, particular instances of benefits, monies, or credits as to whether or not they should constitute public funds. So, to make any recommendations on any of these 5 topics that affect multiple projects, Labor Law Section 224C requires that the board hold a public hearing during which we will hear testimony from interested stakeholders. That is either given in the meeting or provided in writing prior to the hearing. Because of the public hearing requirement, we should not engage in a substantive discussion about the individual topics until we've held the public hearing. I recommend that today we discuss which topics this board would like to consider for recommendation and come to a consensus on how we will hold a public hearing if that's the desire of the board. A few reminders about the potential topics. Sorry. We are not mandated to hold a hearing on all the topics. We can choose to consider all, some, or none of the topics for recommendation. Keep in mind that if we choose to not consider a topic for recommendation now, we can always come back to it in the future if we need to or otherwise want to consider. So this is not one shot and then done. It's open, as we go along. We also need to consider how we want to hold the public hearings. We can choose to have a single public hearing for each topic that we want to consider. We can hold separate public hearings for each topic that we want to consider, or we can choose to group related topics together. Lastly, when we ultimately consider recommendations related to these topics, Labor Law Section 224C requires that we examine the impact of the topics on private development in light of available public subsidies, existing labor market conditions, prevailing wage and supplement practices, as well as the extent to which our recommendation could ameliorate adverse impacts, if any, or expand opportunities for prevailing wage and supplement standards on publicly subsidized private construction projects in any region or regions of the state. To ensure that the board receives the necessary information during the public hearing, we will want to schedule experts to testify. For instance, the Department of Labor's Research and Statistics Office could provide testimony on existing labor market conditions. As we discuss these topics, we should consider how we will ensure that we receive relevant testimony and information to inform our recommendations. We have a few options before us. Let's discuss how we want to proceed. From my perspective, the definition of construction is a topic that has been raised by multiple board members. I think that it would make sense for us to begin with a public hearing on this topic first. Here are some recommendations. We schedule a public hearing on this topic for the end of October and anticipate having discussion on proposed definitions of construction at our December 13th quarterly meeting. We have the Department's Bureau of Labor Statistics prepare testimony on market conditions. We have the Department's Bureau of Public Work prepare testimony on prevailing wage and supplement practices and how a definition of construction will impact opportunities for prevailing wage and supplement standards on publicly subsidized private construction projects in the state. We take testimony from the interested stakeholders and members of the public who wish to speak, but in the interest of time, we limited this testimony to 2 minutes per speaker because we don't want you there forever. So those are my recommendations. I'm going to open the floor to the board for your discussion.
And Madam Chairman, may I make a comment?
Yes, Mr. LaBarbera.
So I disagree with your recommendation. And the reason I disagree is because the issue and the definition of construction is already settled in labor law under section 861-B. There is a very clear definition that is now codified into statute. And I don't see why we would now amend what is already in the state law. And certainly I don't see how it works if you have two definitions of construction. And as you point out, the board may make recommendations and not required to. But again, in labor law 861-B1, definition of construction means constructing, reconstructing, altering, maintaining, moving, rehabilitating, repairing, renovation, or demolition of any building, structure, or improvement or related to the excavation or other development or improvement to the land. So, I mean, that seems to be a good definition. And again, it's already in law, labor law. So I don't know how you have two separate definitions of construction. So that is my thought process on that. I think it's already
Okay.
set.
Thank you. And if you don't mind, I'd like to turn to council because now I need.
Yeah, I'm happy
To wait until everybody.
Yeah, I
Okay.
can answer that question now, but if there's any other board members.
Sure.
have comments or questions on that question, we could do this holistically.
Okay, so other board members want to have, express themselves on this issue.
I would note, though, it looks like Buffalo is muted. Can you unmute Buffalo, please?
Okay, thank you. Good catch. Does anybody else want to weigh in on this question about the definition of construction?
Yeah,
Jim?
Thank you, Madam Speaker. There are multiple definitions of construction in state law and elsewhere. Matter of fact, this has been a topic of conversation between the building trades and Rebney. And I just put it forward that it's reflective that why such a hearing would be desirable on this topic, to hear from a variety of informed sources publicly, so the entire board can reach a resolution.
Anybody else on the board want to express an opinion on any of this?
I would just, 2 comments. I would defer.
Who's that? Was that Hope?
Yes, it is.
Aye.
Hi, I just wanted to express that I think it would be useful to have a hearing on this topic, given sort of the different definitions that do exist across state law.
And Al?
Yeah, well, I would concur with Gary LaBarbera and what he stated. I'm not aware of different definitions of construction, so that's new to me.
Mhm.
My other comment that was on procedure, as Gary said, it's may have a hearing. What would be the procedure for going forward with it? Is it a majority vote or is it a?
Yes,
Okay,
the board has to agree, so it'd be 7 votes yes.
thank you.
Anybody else? Now you can talk to us about the law.
So Gary's correct that there is in labor law section 861-B a definition of construction. However, that definition of construction is applicable to Article 25-B of the labor law, which is more commonly referred to as, the Construction Industry Fair Play Act. 224A, which is, the public subsidy section of law that this board opines on in accordance with 224-C, is in Article 8 of the labor law. The definition of construction for Article 8 of the labor law is actually part of a common law test that has been developed by the courts. It's not enumerated in the statute, but it is a separate review that the Bureau of Public Works goes to determine what is construction or not for purposes of Article 8. In 224A, the legislature defined construction for the purposes of the public subsidy law to be work which shall be defined by the Public Subsidy Board to require the payment of prevailing wage, which now Gary is also correct, and so is Al, that 224C is a may and says that you may make a recommendation with regard to the definition of construction for 224-A. So it isn't mandated that you do it. Until there is a definition that set forth by this board, the Bureau of Public Works will apply the definition of construction that is used from the common law test. It is applicable to other public work matters under Article 8 of the labor law. I've thrown out a lot of articles. Does anyone have any questions to begin with?
Yeah, if I may, through the chair.
Sure.
Okay, so, but what we're suggesting is that there would be a separate, if you went to a hearing and modified a definition, there would be a separate definition applicable to 224A as opposed to Article 8 in the labor law, right? And I think what I'm saying is if you look at the definition of construction that is in 861-B1, it's a good definition. Or the public or the current definition. I don't see why construction under a project that falls under 224A, the definition would be different than that of a project that doesn't. Construction is construction. So that's what I have struggled with.
And taking taking a pause for a moment on that, and that's a very good point that you bring up. And I don't want to get into, this body is empowered with making the determination about what definition should or would apply. So I don't want to get into the merits of it, but this board could absolutely adopt the definition that is currently in labor law section 861-B, which is not currently used for 224A determinations. That this board could decide that they want to adopt that labor law section 861-B definition for 224-A. This board could also decide that they want to adopt the test that has been applied by the courts for Article 8 definitions of construction. The board there's a definition for construction work in the Department of Labor's regulations that this board could choose to adopt, or this board could choose to develop and adopt a different definition. And the merits of any of those choices are for this board to decide following a public hearing and in open discussion.
So I think what our task is not to debate any of the various definitions right now, but to decide whether as a board, we want to hold a public hearing so we can hear the public express themselves and then have the debate and decide amongst ourselves which definition this board wants to operate under. That's the authority given to this board by this law. And as Laura said, that definition could be as simple as adopting what's in the I don't have all the numbers, the reference that Gary used. It could be the standard that Public Works use right now, or it could be a blend of them, whatever you decide. But this allows the board to have a public hearing and then reconvene and have their decision as the law allows. So we're not going to debate the merits of it right now, but that's the decision in front of you. You have the ability to hold these hearings and come to decision, and then that's a settled fact. Does anybody else want to weigh in on whether or not we hold a hearing on this? Okay, so I have heard conversation about why would we hold a hearing, but I've also heard conversation that it would be good to hold a hearing. I'm going to move that the board consider the definition of construction and that a board hold a public hearing. The date of the public hearing will be set by the board secretary, taking into account the availability of board members. The board members will provide their availability for October to the board secretary on or before September 29th, 2023. The date of the public hearing and the agenda for the hearing will be published on the department's website at least 15 days prior to the date of the hearing. During the public hearing, the Department of Labor Bureau of Research and Statistics will provide a presentation on the current labor market conditions. The Department of Labor Bureau of Public Work will provide a presentation on prevailing wage and supplement practices and how a definition of construction will impact opportunities for prevailing wage and supplement standards on publicly subsidized private construction projects in the state. And additionally, the board will allow interested stakeholders and members of the public who wish to be heard on this topic to provide testimony, which shall be limited to 2 minutes per person during the public hearing. So that is my motion. Do I have a second? And this is simply to empower the board to hold a hearing. This is not, you're not weighing in on any of the definitions. Just, do you as a board want to hold a public hearing? Do I have a second?
Second.
Okay. Is there any discussion or comments before we go to a vote on whether or not we hold a public hearing?
I guess my only comment would be if we don't hold a public hearing, we could always take it up in the future.
You could. And what would happen if you don't hold a public hearing is it will revert to the standards that the Bureau already uses, which they were using before the board was originally convened. So we have a standard. We're not without a standard.
So we would be holding a hearing to possibly redefine or define in a different manner what would constitute construction for the purposes of 224.
Yeah.
Which could ultimately run in conflict with what the Bureau and the department has determined through the years, through the common law test and all our case law, is considered construction work.
Yeah.
We could have,
You
it
could,
could put us in conflict, right? If we choose to hold a hearing and air all the different issues and possibly come up with a different definition.
you have to have 7 votes, yes, to come to that decision. But yes, that's true of any public hearing.
So just piggybacking, so the traditional prevailing wage complaints that are filed, the Bureau conceivably would have a different definition than what, after a hearing, we may define for the subsidy. Doesn't make a lot of sense to me.
That's possible.
Yeah.
It's possible.
But that's for you to discuss during the, I mean, that's for your discussion after you have the hearing. You're certainly going to have a lot of information, and you are all experts in your fields. That's why you're on this board, and you'll be able to air these comments during the discussion period before we take a vote if we have a public hearing. So that all this is do we have a public hearing so we can hear from the public, and the board can then affirmatively say this is the standard that we're using, and it can be any of the standards or a new one. Any other questions or comments? Laura?
No, not it.
Okay.
I guess, I've kind of voiced my thoughts on this, is that, if we could take this up in the future, I'm thinking that why not work with what we have now, see how it goes, and if we find fault with it, then have a hearing. And that's just my thought process, why I'm considering not, voting against having a hearing. I
Okay.
just wanted to share that.
Sure. Yep. Anybody else?
Just to clarify, to have the hearing, we need 7.
You have to have 7 affirmatives. Yes.
And then another question. So
Mhm.
currently, when questions about whether or not, based on as the statute is written, whether or not a project would be covered, the Bureau's reviewing those, they're using our traditional.
Our current standards.
Standard.
Yes.
That's in play right now.
Yes.
We'd be opening it up for discussion as to whether or not we're going to change that,
Yes.
Or adopt
not.
it.
adopt.
Yeah. I mean, you have a lot of options. You have certainly 2 definitions that are already accepted on the table. And then the third option is to do some combination or a different, but the standards that the Bureau was using before this board was convened are the standards that will continue until the board has a public hearing and changes it. So everybody understand what they're voting on? All those in favor of holding a public hearing, please say aye.
Aye.
3. All those opposed, please say nay.
Nay.
Any abstentions? So the motion fails because we have 3 ayes and 4 nays. 5, yeah, I'm sorry, we're 8 people, 5 nays. Okay, we are going to continue with the definition of construction as we have it now. Okay. My next question is, are there any of these other topics that anyone wants to take up as a public hearing at this point? We have 4 other topics that we can consider. You don't have to consider them. And as you just said, you can always come back and revisit them. Are there any of the other 4 topics that anyone wants to bring to a public hearing at this point? No. Very good. So that covers the discussion around these 5 topics. One thing I want to point out, I realize that we're going to have questions and concerns as we continue our work on this board about other issues that will come up as we dive into the substantive work. And we do not have to have a special session for questions and concerns that arise. We can always discuss those during future meetings. The only special public hearings we are required to hold at this point are for the 5 topics that were laid out in the law. So any other questions that we have about what do you mean by this? How does this apply? That's general course of business, and we can have those conversations. I know it's been a concern for several board members, and that's what we're here for. So that's just normal care part of business. So at this time, I'd like to ask the members of this body if there's any other business you'd like to address before we move into executive session. Nope. Okay. During the next portion of our agenda, the board will be discussing specific projects that the board members received prior to today. Consistent with the board's procedure and the confidentiality requirements set forth in labor law, section 224C5, I move that the board enters executive session. Do I have a second?
So moved.
Thank you. All in favor of going into executive session, please say aye. Opposed? Not voting? Unanimous. We will now end the live stream, and we will be closing the doors to the public to enter the executive session. When the executive session has been adjourned, we will reopen the meeting rooms to the public. Thank you. We're going to wait for Leah to confirm that all the non-people are off. Okay, I'd like to welcome back any members of the public who are attending today's meeting. We had 3 projects presented to the board in executive session, and the board unanimously decided that 2 projects were not covered. 1 project was covered, and that the details of that will be in the minutes posted on the website. For our last order of business, I actually have a question from the board that we'd like to discuss. We have 2 orders, so let's discuss the question in public meeting. Would you question?
Sure. The example of Foundation for Fair Contracting, auditors projects, can they submit the inquiry of whether or not a project is covered?
So the form was developed for an owner or developer to submit based on the way the statute was written. However, a request for the project to be reviewed. So far, what I have been doing is no matter who it comes from, how it comes to my attention, I have been generating a report on all of the projects to submit to the board. So we have the opportunity to weigh in. If a non-owner developer opted to use a PW 930, form, I suppose they could. A little awkward filling out some of the boxes, and it's, but we would still consider it. Take that in context and still prepare a report for the board.
Okay. Okay. So our last order of business, we're going to discuss our quarterly meeting schedule for the remainder of this year and then next year. Our next meeting is scheduled for Wednesday, December 13th, 2023. It will begin at 11 a.m. For 24, we will be meeting on Wednesday, March 20th, Wednesday, June 26th, Wednesday, September 25th, and Wednesday, December 11th. Each of these meetings will begin at 11. Please keep in mind there may also be additional meetings determined. Our agenda for today. The materials, including meeting, will be posted on the boards and committees section of the Department of Labor's website. And as we've reached the conclusion of today's meeting, I move that we adjourn. Do I have a second? Second. Okay. Without objection. Thank you very much. I appreciate the work that you're doing. I know that the governor appreciates the attention to these projects, and certainly the people of the state of New York appreciate it. So thank you very much. See you all soon.